CLJ sessions of white collar crimes in India. I'm Neeha Nagpal, and today I'll be guiding you through the bail law in relation to white collar crimes. If you remember, in the last session we had spoken about investigation into white collar crimes. What we had discussed was there was a unique feature to white collar crimes, which was a multi-agency probe, which could vary between the predicate offence, which is FIR by CBI and EOW, leading to Prevention of Money Laundering Act investigation by the Enforcement Department, and potentially where a company was involved, the involvement of the Serious Fraud Investigating Office, SFIO, under the Companies Act. So as a consequence to a multi-agency probe, we also have the issue of a multi-agency arrest. Now we come to really what is the bail law when it comes to white collar crimes in India. So white collar crimes in India really, were on the advent from 1980, when there was, or maybe the late 80s, early 90s, when the economy started opening up. The real jolt that the economy, the white collar crime scene saw was in 2009-10, when the 2G scam broke out. So the founding judgment really, or the landmark judgment on the issue of bail in large economic crimes, which have a huge consequence on the economy, is in the case of Sanjay Chandra versus CBI 2011 SCC. So that revisits the entire bail law right from back in the 1970s to 1960s, and establishes a position which basically says that upon filing of charge sheet and upon completion of investigation, bail should be granted. What is the objective of bail is also discussed. The objective of bail is really to secure the presence of an accused through the process of criminal trial. And that sort of gathers relevance because we are faced with a situation where we need the trial to commence, the trial to be completed on time, and we don't want any obstructions. Especially what is seen as economic offences, where in a lot of cases where bail has not been granted subsequent to Sanjay Chandra's judgment, in the case of Neeha Yadav and Jagmohan Reddy, which are under PC Act and PMLA Act, it has been held that large economic offences cause a lot of damage and prejudice to the economy. They are sort of insidious crimes which are pre-planned, premeditated, and therefore they should, the vigors of the law should be harsh, I wouldn't say harsher, but I'd say should be more stricter. As time has gone by, since 2011, the law has evolved on white collar crime bail. We have also seen how twin test, which is found in essentially large number of statutes pertaining to economic offences, such as it used to exist till the Nitesh Chandra judgment in 2017 in the Prevention of Money Laundering Act. It exists today in the Companies Act under section 2126 of the Companies Act 2013. It also exists in relation to the Maharashtra Control of Organised Crime Act, Terrorist and Destructive Activities Prevention Act, the NDPS Act. And how does one get over the twin condition? The twin condition really says two things, as the name suggests. One, that before any decision on bail or a bail application is taken, the public prosecutor be heard, which is fair enough. The second is slightly onerous, which says that the judge has to come to a finding that no offence is made out against the accused. That is really, as has been held in the case of Nitesh Chandra Jain by the Honourable Supreme Court Justice Rohington Nadiman's judgment, is that it is violative of Article 14 and Article 21, and therefore it has been struck down. Post that, bail in matters pertaining to Prevention of Money Laundering Act has been seen to be read in the same parlance as bail under the CRPC. Though of course Parliament in its wisdom did amend the PMLA Act in Section 45 of the PMLA Act in 2018 post the Nitesh Chandra judgment, but various high courts have held that amendment does not reinstate the twin conditions in the PMLA Act, Samir Bhujbal's case in the Bombay High Court. That issue is now at large before the Supreme Court in the recent case where Dr. Shininder Mohan Singh was given bail in the Religare Finvest matter and, under the PMLA Act by the Delhi High Court. And the Enforcement Directorate went before the Supreme Court, and that issue, whether the twin conditions have been reinstated by virtue of the 2018 amendment, are at large before the Supreme Court. The other aspect on bail that is relevant is the SFIO bail issue, where the twin conditions, as mentioned recently, are under challenge before the Honourable Supreme Court. And the Honourable Supreme Court has, in various cases, granted no coercive steps where petitioner has not been arrested. Having said that, so far just 2 accused have been out, and I understand that about 37 have been arrested by the SFIO under Section 212 of the Companies Act, and only about 2 have been granted bail on medical conditions. One is Prabhat Srivastava and one is Gaurav Kumar by the Honourable Delhi High Court. But those have not been granted bail on merits. They have been granted bail relying on the exception to Section 2126, which talks about medical health. They have extreme medical health conditions and therefore they've been granted bail. Nitin Johri, the CFO of Bhushan Steel, who's been arrested under Section 2126, was granted bail by the Delhi High Court. The SFIO went in appeal before he was released from jail and got a stay of the order, and then that order was set aside by the Supreme Court. Of course, now his second bail is pending before the Supreme Court, and also his challenge to Section 2126. Having said all of that, in sum and substance, multi-agency arrests and white-collar crime bails do create a fair bit of trouble, because there is a lot of stigmatization attached to it. That it's a huge 1,000 crore scam, 500 crore scam, public money, where of course bank issues are involved, siphoning of funds. So the sentiment becomes very important, but one has to realize that bail is required for even the accused to defend himself, because in most cases these transactions which are at play are within the specific knowledge of only the person who's accused of them. And it's been held by the Supreme Court right from the case of Guddi Kanti in 1997 down to Sanjay Chandra in 2011, repeated in Mr. P. Chidambaram's case in 2019, that bail should be considered even in economic offences where to enable the accused to prepare his defence sufficiently. Mr. P. Chidambaram's case, bail case, involves a tripod test which talks about 3 things have to be satisfied. 1, that the person will not flee from justice, which is basically will cooperate with the trial process. 2, person is not a flight risk. 3rd, will not tamper with evidence. So I think really, if you look at it, this is what bail jurisprudence says, that you should satisfy these 3 tests. And of course, the stage at which bail should be granted has been propounded to be once investigation is complete and charge sheet is filed. The logic to that is that all the investigation material is within the custody of the court. What is relevant and a special feature in white-collar crime cases is that mostly it's document-oriented, which is either ROC records or banking transactions or statements of accused which are taken, or ledgers, books of accounts. So all of that cannot be changed. So all the relevant material in any event cannot be tampered with, because now it's been filed with the court. So I think that is an important criteria that should be considered. As regards the twin condition, the Punjab and Haryana High Court in an SFIO matter pertaining to the Adarsh scam has sort of said that it's not relevant to decide on bail. But however, they did not grant bail to Mr. Rajkumar Modi there. So there are cross SLPs by SFIO objecting to the observations as regards to 126, and of course for rejection of bail by the petitioner. That's pending at large before the Supreme Court. The Supreme Court has granted interim bail while the issue is still to be considered. I hope this session has been informative for you, and I'd like to just sum it up for you to say that bail is a right. Bail is, as the law says, that bail is the rule and jail is an exception. That's the way it should be. Bail should not, bail at this pre-trial stage should be given, because you cannot be punished. The criminal jurisprudence does say that you are innocent till proven guilty, and it aids and helps the accused in preparing a strong case for his defense. Thank you.